Years ago, I represented a target of a subpoena, and when upon receipt of it, I realized that the content that was requested would be, if disclosed, violative of any number of principles of confidentiality. I asked then, obviously, I challenged the subpoena in court, and there were then opportunities to talk about what should be protected and what shouldn't. When I look at the sequence of events that have transpired here, and I look at, by the way, I'll get to the point here in a minute, which of course is our resolution, but when I look at the sequence of events where the Attorney General's office was working with the former president and his team in obtaining various records over the course of over a year and a half, I wonder why the process that was used was not the one that we followed back in our little Oregon, because it's so obvious that the process that was used was not necessary. The process of raiding the former president's home. What should, and it's been raised over and over again that this is not what happened to Hillary Clinton, and this is not what happened in previous similar situations. And instead, the dialogue continued. Certainly not what happened here. The appropriate action here would have been for the grand jury to issue a subpoena for the boxes of material that they had just seen a few days earlier, and then Trump's lawyers would have had the opportunity to challenge the subpoena on various grounds. And then they could have sorted through which material was classified, which material reflected attorney-client privilege. That's what should have happened, but for some reason it didn't. Now, people can go back and say, well, a subpoena had been filed earlier, but that was months earlier. There had been ongoing dialogue right up to the point of the raid. I don't get it.
Mr. Benson, if you'll yield.
Let me finish. No, I'm not going to yield.
All right.
What I find interesting is because there were alternative tools available for the AG to use, and he chose not to. You have to ask, why would the Attorney General want to throw, as I've said earlier in other interviews on this topic, gasoline on a political fire? Why? What could possibly be the benefit? Well, I know, because this is a political matter, and the other focus on issues involving our former president was wearing thin, and this gave an opportunity for a new focus, which is exactly what we're about today. But what we're trying to do is perhaps bring this dialogue to an end by looking at the very affidavit that prompted the raid. Now, that affidavit better contain all kinds of things that say those records were about to be destroyed. Now, you know what? They weren't. The president was 1,000 miles away. So, that's why you go into one of these things with a search warrant, because you fear that there's going to be something that you're trying to lay your hands on that's going to disappear. But I actually, looking at a editorial here, it's important to note that Trump himself was 1,000 miles away when the FBI's search and seizure occurred. It would have been impossible, therefore, for him to destroy the subpoenaed evidence, especially if the subpoena demanded immediate production. If he or anyone else destroyed the evidence subject to a subpoena, there would have been a far more serious crime than what the search warrant seems to have alleged. What we're asking today is, let's see the affidavit. I mean, what's everybody scared of? We'd like to see it. Maybe it's good, maybe it's bad, but we'd sure like to see it. You know what, I'm going to yield to Mr. Bishop of North Carolina.